because this protection wasn't in place. Finally, let's talk about exit rights and legal remedies under Florida law, because in a private company, you can't just sell your shares on a stock exchange. Florida provides several statutory remedies when things go wrong. First, there are appraisal rights. If the company undergoes certain fundamental changes like a merger, share exchange, or disposition of substantially all assets, and you're entitled to vote on it, you can dissent and demand that the company pay you the fair value of your shares as determined by a court. Now, the procedures are strict. You must file written notice before the vote, not vote in favor of the transaction, and make a demand for payment. But this gives you an exit when major changes occur. Second, Florida law provides for derivative actions. If the corporation is harmed by wrongdoing of directors or officers, you can sue on behalf of the company. The current version of the statute requires you to make a written demand on the board of directors and wait 90 days unless you allege in your complaint why making a demand would be futile. This is a powerful tool for minority shareholders. Third, Florida law allows shareholders to petition for judicial dissolution in specific circumstances. If directors are deadlocked and shareholders can't break the deadlock, causing injury to the corporation or preventing business from being conducted to the advantage of shareholders, you can ask a Florida circuit court to dissolve the company. You can also seek dissolution if corporate assets are being misapplied or wasted, or if directors are acting illegally or fraudulently. Now, here's what makes Florida law particularly protective. When you file for judicial dissolution, the other shareholders or the corporation can elect to purchase your shares at fair value instead. This creates a buyout mechanism even when there's no agreement in place. It's a powerful exit strategy for minority shareholders trapped in a deadlock situation. Look, understanding your rights as a shareholder in a Florida private company isn't just about knowing what's in Chapter 607. It's about protecting yourself before you invest by getting the right provisions in the Articles of Incorporation and shareholder agreements, knowing when to exercise your statutory rights under Florida law, and understanding the remedies available to you when things go wrong. The shareholders who win in Florida are the ones who understand these statutes, negotiate protective provisions up front, and enforce their rights when necessary. Now, with this deep dive into Florida shareholder law